All right. Good morning, everyone. I'm the staff attorney for Judge Krause, Mitch Shrioff. Thank you all for joining us. I see we have a court reporter here, so somebody's requested takedown, so that's great. All right. We have about 6 matters on today's calendar. The judge will ask for announcements at the start and probably take them in order of least to most complicated. We have a couple of status conferences, and then some more media hearings. For the Scheiber v. Horstman people, I think you've gotten my emails. I'm not sure what the judge is going to do. She may be resetting this pretrial conference, so we'll see what happens. I know there's some leave of absences in place, so you might be wanting to think about when you might be available to do that in the next coming days. I think our trial calendar begins on the 17th this month, so we'd have to sneak something in relatively soon here. Yeah, correct. Monday the 17th. So, all right. Judge is going to be on momentarily. I'll let her take it from there. Please know we are broadcasting live to YouTube in accordance with an open courtroom policy. So you may want to monitor your conversations if you're not muted. And when it does come your time to talk, make sure you are unmuted. That almost always happens for somebody. So, all right, we'll see you in a moment.
Good morning, everyone. Sorry if I'm a tiny bit late. I appreciate your patience. And I am ready to go ahead and get started. What I'm going to do is just run very quickly through the calendar, see what announcements we have, and then go from there. And then we'll figure out what order to take whatever substantive matters we have left, pick up from there. Starting with position 1, Schreiber, versus Horstman. I am aware that there was a leave of absence filed for Mr. I'm sure I'm mispronouncing Evie. And there was also a conflict filed by another attorney that had to be elsewhere. Do we have anyone that's on the call for that matter?
Yeah, good morning, Judge.
Your Honor.
Okay, hi, Mr. Bossler and Ms. Best. I think that's who I heard speak.
Yes, Your Honor.
Go ahead, Mr. Bossler.
Good morning.
Good morning.
I'm here on behalf of the plaintiff. I know Jimmy Cannella has indicated he's got a conflict this morning. He's trying to jump on when he can.
Okay.
I don't know if you want to get into any of this other than to share with you. I'm cautiously optimistic we may be able to resolve this in the near future.
Okay, well, I always like to hear that. Ms. Vest?
Good morning, Your Honor. I'm here on behalf of Jacob Eby.
Oh, I did pronounce it right. Good for me.
You did.
Okay, and so what I will do, if y'all will be patient with me, and I certainly understand if we're waiting on Mr. Cannella, feel free to turn off your cameras and multitask and do other things that y'all need to take care of. But if you'll stick with me for a little bit until we can get an announcement for Mr. Cannella, and then we'll go, and I'll be able to give you some guidance about when I think the case would go if there is not a resolution. Okay?
Thank you.
Thank you
Thanks.
both. Carr versus Akshata.
Erin Willoughby for April Carr, Your Honor.
Yes, ma'am.
Matthew Carlton for Akshata LLC.
Okay, and excuse me, what is your announcement in terms of how long you believe it will take today?
Well, it's going to be a bench trial, and I think it would be probably not even a full day, but we probably should at least schedule a day.
Yep.
I would agree
Just-
with that, Your Honor.
Excellent. And that really is one of my goals this morning, is to just sort of figure out when it will fit on my calendar and how long you actually think it will take to conduct the trial. And then we'll, give you guys some guidance on anything that y'all need. And then we'll go from there. So if you guys will hang on for just a little bit, I will circle back to you. Okay.
Thank you.
Thank you, Your Honor.
Thank you. Okay. Excuse me. Next up is Modality Systems Limited versus Premier Global Services.
Morning, Your Honor. Scott Halsey on behalf of Modality Limited.
Okay.
Your Honor, Larry Oldham on behalf of Premier, and I'm sorry there's something going on with my video. I don't want to be like that guy that had the cat face on his on his video. So if I can figure it out, I will do that. But otherwise, I am here and ready to proceed.
Well, unlike my criminal defendants who are on bond that I require to turn on their camera so I can see them, I'm going to accept you at your word, Mr. Oldham, that you are Mr. Oldham.
Okay, thank you, Judge.
No problem. And this is an effort to domesticate a foreign judgment, and rarely, they don't come up as often, an actual foreign judgment, right? From, I think, Britain. And there was an answer filed, which sort of changed up a little bit of the process. So what is it that y'all think we need to take care of today, and how long do you think that it will take?
Judge, on our end, this is usually fairly pro forma. In fact, it's usually resolved on the papers. We imagine for us, it'll take a half hour to an hour at most to establish our burden, to domesticate the judgment. And just so you're aware, we have the client, our witness, expert witness, and then other attorneys from my office on the line.
Okay, thank you, Mr. Halsey. I appreciate that. And on behalf of the defendant.
Well, Judge, it shouldn't take too long. Some of the evidence, I did get the exhibits and that. I had not seen any of this evidence before today. I'm actually local counsel for this defendant that,
Yes,
has New York counsel. And so I've filed an answer that I was requested to file. And then I've I know very little about the case other than that. I did see the pleadings that were filed, so I think we'll let plaintiffs put on their proof, and then Your Honor can make a decision based on whether or not it's appropriate to domesticate the judgment.
Okay, well, thank you, Mr. Oldham. I appreciate that. And I've
right.
written down about 30 minutes and we will come back to you guys in just a minute. Did
Okay.
y'all, I don't see my court reporter here, so although currently civilly I've asked, yes, I do see a court reporter here. That's what I was looking for. Thank you, Ms. Elder, for making yourself seen. I appreciate that. And so I assume that means Mr. Halsey and or Mr. Oldham that y'all requested take down.
We did, Your Honor. Thank you.
Okay,
And
excellent.
Judge, I'm going to try to get my video working, so I'll leave and come back.
Yeah,
Okay?
feel free.
You're not going to hear us right immediately. I don't
Yeah,
think.
it's gonna be, my guess is 10, 15 minutes at least before I get to
Okay.
you guys.
All right. Thanks, Judge.
Thank you. Okay, next up is Freeman versus Bruce Thompson, Commissioner of the Georgia Department of Labor and Delta Airlines. Who do I have in that matter?
Good morning, Your Honor. Max Wallace on behalf of petitioner George Freeman, who's also attending today.
Okay, and who do I have on behalf of either the Commissioner or Delta or both?
Good morning, Judge. Ryan Kolb on behalf of the Commissioner.
Okay. And I am aware that this is an appeal of a prior decision. How long do we think that it will take to present, Mr. Wallace?
I don't think very long, Judge. I think most of our arguments in our briefing, maybe 5 to 10 minutes for me.
Okay, Mr. Kolb?
Maybe 5 minutes, Judge.
Okay. Thank you. And then we have Tyshawn Tribble versus Ralph Gershom. Who do I have in that matter? I think I see Mr. Douglas and Mr. Van Gelderen. How are you, sir?
I'm here. Good morning, Your Honor. Chuck Douglas for Ms. Tribble.
Okay.
I'm in Judge Dunaway's courtroom in person as well.
Okay. So I've seen your filings. It feels like we just need to sort of have a status conference about what has occurred, which I anticipate will take about 5-ish minutes. Any different thoughts on that, Mr. Van Gelderen or Mr. Douglas?
I haven't seen anything that's occurred that would change the case at all, other than
Well,
payment.
certainly we need to discuss that, Mr. Van Gelderen. My point was simply acknowledging that Mr. Douglas had filed some things that we needed to have a discussion on what effect that had on this case.
I haven't seen anything other than an entry of appearance.
Okay, and that may be, Mr. Douglas, did you provide those to Mr. Van Gelderen versus by email? Because I received them by email, and as far as I can tell, they have not. The clerk's office, I think, is behind because of the holiday.
We mailed a hard copy to his office as well as e-filed, and I believe he was copied in the e-filing with the court.
Right, but the e-filing doesn't get generated until the clerk accepts the filing, and those filings have not yet been accepted, Mr. Douglas, because they were filed on the Thursday before a holiday weekend.
I understand.
Go figure.
We did in fact mail a hard copy as well.
Okay. Well, we will have that.
Order that I'd like to see it.
Yes. Well, here's what I'd like to happen. We're going to circle back to this case and have a conversation for a few minutes about what it is. In the meantime, Mr. Douglas, if you have staff or if you're able to do it on your handy dandy phone, and please email those documents to Mr. Van Gelderen. Mr. Freehoff, I know, also has those documents. And so, Mr. Van Gelderen, if we have an email address for you, Mr. Freehoff will email them to you as well.
Thank you.
Mr. Freehoff, do we have an email address for Mr. Van Gelderen?
I have been in email contact with Mr. Van Gelderen before, so once I find those documents, I will send them as well.
Excellent, thank you. Okay, and then
Judge, is it okay if I get back into Judge Dunaway's courtroom?
yes. But I need you to stick with me if you want to go dark for a few minutes, but I'm gonna be calling on you again in probably 20 minutes, 10 minutes,
Okay.
maybe.
What I was asking. Thank you so much.
Thank you. And then next is Brentwood Place Community versus Fatuma, or excuse me, Foinke, Bangura, and Diabate.
Good morning,
Mr.
Judge.
Woodworth, how you doing,
Yeah.
sir?
Good, how are you?
I'm doing fine, thank you. So my understanding of this case is that Mr. Foinke, I say Mr., I don't actually know. Respondent Foinke filed an answer and also a counterclaim. There was a default entered as to Diabate, and there's been notorious service as to Bangura. And potentially the time has passed for a default. Is that an accurate assessment of where we are currently?
Yes, Judge, as far as Bangora, their time to open default just ended, I believe, on Monday. I did not recall the counterclaim, but I will look that up. My intention now, since I believe it's Ms. Foinke who did file an answer, was just file a motion of summary judgment as to all three defendants. If I do need to do something about that counterclaim and potentially have it moved or dismissed, I'll do that as well.
Okay. So Mr. Woodworth, if you would do me a favor and just briefly walk me through the proposal for the default judgment as to that third defendant, or do you need to submit that paperwork in terms of the Rule 15 affidavit and other things?
I would need to submit that. I haven't done that yet. Like I said, it was just this, I think Monday that 45 days was up.
Okay, well, just so you know, that's why we set the hearing today, because
Oh, okay.
it gets a little complicated with multiple defendants, but that's actually
Sure.
why we set the hearing today, because we had also timed it out and determined that that defendant would either have answered or would
That's right.
be technically in default by this point, and then we would know that we were just dealing with the one defendant or otherwise. What I'd like for you to do is to please get that paperwork to us on the default. To the extent that you are asking for attorney's fees, we will then set you for another hearing, although it will be quick. And then we will look for whatever filing or response you intend to make regarding the respondent, Foinke, who did answer.
Yes, Judge.
Okay, and unless you needed anything else on that case, you may be excused, Mr. Woodward.
Nope, that's it, Judge. Thank you very much.
Yes,
Judge,
Mr.
if I can
Freehoff?
jump in for 1 second. Mr. Woodworth, part of the confusion might be that Ms. Foinke titled her pleading an answer to complaint and counterclaim for garnishment. But when you go through that pleading, you may have some thoughts on whether it constitutes a counterclaim or not. But you can find that in her answer filed on March 21st.
I'm just pulling that up now. I'll have to look through it again, but
Okay.
now that refreshes my memory. I recall that it was titled as counterclaim, but I don't remember actually seeing any actual counterclaim in there. So
Yeah, I won't speak to that, but I just wanted to point you out why
Sure.
maybe the word counterclaim has appeared. Okay.
that's right. That refreshed my memory now. Thank you.
Thank you.
All right. Have a good day.
You too. And then we have Wimberley versus Haviff, which we already resolved at 8:30 this morning. Okay, so here's what I'm gonna do. I am going to, I don't think that I have Mr. Canella just yet. Do I? Okay, so I think what I'm gonna do is call on the Carr versus Akshata attorneys, and let's just talk through briefly what your bench trial is gonna look like and how much time you think it will take in terms of scheduling. Mr. Carlton and Ms. Willoughby, is that right?
Yes, Your Honor.
Okay. What are our thoughts on, are we talking a half day? Are we talking a full day?
I believe Mr. Carlton as the I would defer to Mr. Carlton for the length of time.
I
his
mean, I think
presentation would
my
take.
case will take an hour. I mean, so I think it's a half day. But you know, there's like 4 or 5 witnesses listed. So there's not a ton of documents. I think we're pretty much in agreement on most of the documents that are on both our lists. So, I mean, I think it could be done in a half day. I just don't want to say it could be done before lunch, you know, I mean, if we start at 9, I think we could be done by 1:30 or 2. I think that would certainly be extremely reasonable.
Okay,
I just
Ms.
don't
Willoughby?
think 9
Oh,
to 11 is, I think 9 to 11 may be pushing it a little bit.
I
Fair
agree. I
enough.
think 9 to 11 may be pushing it, but I think we could be done by mid-afternoon.
Okay. Well, what I would likely do is I hold days for bench trials like these. And so what it would likely be, I don't know exactly the day, but it would likely be on a Friday, sometimes on a Thursday. It will most likely be in the middle 2 weeks of July. And so soon. And it would likely be that I would set it for a 9:30 start and we would just go until we were concluded.
Okay, I have on July 11th, I have another bench trial.
Certainly, I understand. And when we provide you with notice of what the day is going to be, if there are conflicts, let us know. We're happy to work with y'all.
Yeah,
We just find that the best thing to do is just go ahead and get it on the calendar, and then y'all tell me if there's a problem and we'll move it around if we need to.
I agree.
Okay?
Thank you, Your Honor.
And actually, in fairness, I do think I would be looking at either the end of that week of July 11th or the beginning of that next week, July the 17th. So just so you have some idea of where I'd be targeting, but I'll talk with Mr. Freehoff about our availability those weeks.
All right, thank you.
Thank you,
Your
but we
Honor.
will send you, yes, ma'am, Ms. Willoughby.
I just said thank you, Your Honor.
We will send you a notice of hearing for the bench trial probably later today so that y'all will have as much notice as possible. And I will let you know that the information about when the trial is set may contain different information, but I will tell you that currently my court reporter is not available for civil work. So to the extent that you want it taken down, you are going to need to secure your own court reporter, okay?
Thank you.
Thank you.
Judge, may I
Yes.
ask a question? Or will this be an in-person or a Zoom-based bench trial?
It's entirely up to the lawyers. We're available. We're here. We're happy to have it in person. But of course, the parties need to both agree if we were to conduct the proceeding by Zoom. The parties would both agree to conduct the entire proceeding as well as to allow the witnesses to appear remotely. What are your thoughts on that? I don't think it matters. I will tell you, I don't think it matters for scheduling from the court's perspective because I will be at my office while I am entertaining this trial. So whether I'm sitting on the bench or sitting in front of my computer, it doesn't matter to me.
I'm happy to do Zoom.
Ms. Willoughby?
I am from a sort of legal issues and scheduling perspective, I have no problem with doing Zoom. My concern is that my client may not feel that she's sort of getting her day in court if it's done over Zoom.
I understand, and that's why I let you guys know. Here's
and-
what I'm going to ask you to do, Ms. Willoughby. We're going to send you guys a notice. Again, it doesn't affect my scheduling of when the day would be. And then you both would have an opportunity to respond and advise if you are in agreement to proceed by Zoom, or if you are not in agreement to proceed by Zoom, let me know that. And then I will make sure that the parties are clear that the matter will be handled in person, but it will not change the date or time that we would schedule it.
Thank you, Your Honor.
Okay, thank you
you.
both. Although, Ms. Willoughby, in fairness, I would expect if we get that notice out to you today, that I would hear back from you no later than tomorrow, just so we're clear on what we're all doing.
Yes, Your Honor.
Okay, thank you.
Thank you.
Thank
You
you.
both
all.
may be excused unless you need anything else from me.
No,
No,
Your
Your
Honor.
Honor.
Okay, thank you.
Thank you.
Okay, Mr. Wallace and Mr. Kolb,
Yes, Your Honor.
did you request the services of a court reporter?
No, Your Honor.
Okay, and Mr. Halsey, I'm just going to call on you because you happen to be most available to my eyes on my
Yep.
screen of lots of lawyers. I should have said sooner, and I apologize that I did not. I know everybody here, very busy people. To the extent that you need to go dark and step off, it is almost 10 o'clock. I suspect in fairness, I'm not going to get to you guys until 10:15, 10:20. So as long as you are available to jump back on and target that time, you all are free to be attending to other matters while you wait. You don't have to sit here and be physically available on the screen. So.
Understood. I guess the only request I would make is just as soon as we can get to it, we have a general counsel from a company on the line. We have an expert witness and a court reporter that we're paying for. So the sooner we get to it, the better. We're ready to go. But if you're saying 10:15, then we'll. plan
Yeah,
to come back
and
on
I
it.
apologize for the delay, but I know that your matter is going to take the longest and needs my undivided attention. So I'm trying to get rid of everybody else as quickly as I can. I do expect that it will take, that we'll be ready at 10:15 to take up your matter and go from there.
Okay, we'll be back on in 20 minutes then.
All right.
Thank you, sir.
Thanks, Judge. I'll be back at 10:15 as well.
Thank you.
All right.
Okay, sorry about that. Mr. Wallace and Mr. Kolb. Do you wish, Mr. Wallace, to go ahead with your presentation, sir?
Yes, thank you very much, Judge. So we are here on a petition for judicial review asking the court to reverse the Department of Labor's denial of unemployment insurance benefits to Mr. Freeman. And the department based that decision on a finding that Mr. Freeman was highly likely to be terminated from his employment at Delta. And as a result, he accepted a voluntary severance package. But based on those facts, the department did not find that he qualified for unemployment insurance benefits. And we think that the court should reverse that determination. The legal standard allows for an employee who voluntarily separates from employment to still get unemployment benefits, so long as that voluntary separation is for good cause connected to work. And the statute cited in our brief and the corresponding regulations speak a bit more as to what exactly that is. The pertinent statutes are OCGA 348194, and the pertinent regulation is 300-2-9-.05. And interestingly, in its review and its determination, the department didn't cite to these pertinent regulations at all. And so if the court would allow, I'd like to give a little bit of factual background just surrounding the circumstances of Mr. Freeman's departure. And then
I'm always happy to allow that. But in terms of saving you some time, let me tell you what I think I know about the background of your case, having read the brief, and you tell me if any of that is not right or if I'm misinformed, right? So I understand Mr. Freeman was a longtime employee of Delta, and when the pandemic happened, the bottom dropped out of the airline industry, and Delta, as many other airlines were required to do, had to start shedding jobs left and right. They made a decision, a business decision of some sort, to do a calculated, reduction in force, which, as with companies, as they always do, they always start with the people who are closest to retirement, et cetera, et cetera. I believe I understood you to point out that Mr. Freeman was in that category, and was offered an opportunity to take an early retirement / severance package / whatever we're going to call it, took it, and then was not able to secure later employment at a time when he thought he should be eligible for unemployment benefits, made that application, and it was denied because he had received the voluntary buyout. That's what I think I understand, and anything else that is more nuanced than that and important for me to understand now would be your opportunity to point it out.
Of course, and that's all correct, Judge. What I would add is that Mr. Freeman didn't really have a choice when it came to continuing with employment. So the initial determination of the department was, well, he could have stayed in this job. And then as the review went up and it finally got to the board of review, the board determined, well, it was highly likely that he was going to be one of 80% of employees that were going to be laid off if he didn't accept voluntary retirement. And so it was highly likely that he would be terminated. And from my review of the record, it appears that the department based its denial on the fact that, well, he was highly likely to be terminated, but he wasn't certain to be terminated. And so we think that basing the decision on that distinction was error. And then the only other thing that I would point out to the court, I apologize.
No, please
go
ahead.
Question, Judge? Okay. The only other thing I'd point out to the court is that the governing regulations say that in order to be deemed to have voluntarily left employment with good cause as part of an employer package or separation program, the individual needs to be advised of an actual impending layoff with a date certain, and the effective date of that layoff needs to be no more than 6 months after the announcement date. And we believe from the record that we have that Mr. Freeman was advised of an actual impending layoff of the date certain. If you look at Claimant's Exhibit 1 in the record and also the hearing transcript, Mr. Freeman was advised multiple times by regional and national management, both via telehearings and through memos promulgated by Delta, that if they did not receive sufficient government aid and sufficient reduction in force by September 30th, that layoffs would begin. And those layoffs were, to quote the record, Judge, highly likely to include Mr. Freeman. And so we think that based on those two factors, that he was given a date certain of impending layoffs and that it was highly likely to include him, that either good cause exists for the grant of unemployment benefits, or at the very least that it should be remanded to the department to consider those facts, because the record just really doesn't engage with that analysis at all.
Okay, thank you, Mr. Wallace. Mr. Cole?
Good morning, Judge. I don't think I really have all that much to add to what Mr. Wallace has said. I think that the crux of this case focuses on that date certain language. Having reviewed the record myself, having reviewed petitioner's brief, I see no date certain in there. I see a high likelihood of termination, and that those terminations or layoffs would begin at the end of September. I just see nothing in there that says, Mr. Freeman, here is your notice that you will be laid off beginning September 30th, 2020.
But does that, forgive me for interrupting, Mr. Cole, but does it matter that although Delta did everything in its power to structure it like a statutorily compliant reduction in force with proper notices and everything else, that at the end of the day, this was not, I mean, this was a business decision created by a insane set of circumstances that was rolled out very quickly. How does the fact that even though they were able to delay it long enough to keep their employees on the payroll for a longer period of time, but ultimately their hand was forced by the global pandemic, how does that affect the decision-making process? That's my first question. And my second question is, even if you're right, what about Mr. Wallace's point that there's not a sufficient record from the decider below in terms of the statutory justifications, et cetera? Those are really my two questions for you, Mr. Kolb.
Sure, Judge. If I could start with the second.
Sure.
As far as there being a sufficient record, I think that the notice was presented in the record. There was a hearing transcript about what he was advised by Delta. All of that pointed to a high likelihood of termination at the end of September. So I think that is sufficient. Again, it's what's not in the record that's really the issue, and that's that date certain. And going to the effect of just how a rush process and COVID and everything that these companies were having to deal with in the decision-making process, I'm not sure that I can speak to that, and that it gives the ability to essentially negate an element of these regulations. I certainly understand it, but I'm not familiar of any excuse or waiver that it provides.
Right. Well, I certainly agree with you there. It's more that if the date certain is what is the critical point here, is it possible that Delta was not in a position to provide that date certain such because of the speed and manner in which all of this had to be undertaken? The urgency.
No, I understand. I think that from the record that Delta wasn't sure who was going to be laid off where, and they were trying to mitigate layoffs. They weren't sure who was going to get it, and like Mr. Wallace said, it seemed to be dependent on how many other employees took these severance packages or early retirements. My guess is that if it had gotten to the point where Mr. Freeman stayed on until the end of September, he may have gotten the date certain at that point, but we obviously don't know that.
Okay. Well, I have read your briefs. I wanted to hear from you guys in terms of answering those sorts of questions. Mr. Wallace, I am going to take this under advisement and then advise the parties what my ruling is going to be, but it is your motion. And so if you would like, you may have the last word, sir.
Yes, Your Honor, just briefly. The only thing I'll say is that as to whether or not September 30th qualifies as a date certain, obviously it's our position that it does. And it's our view that Delta was certainly portraying that date as a date certain to its employees to incentivize them to take action, right? They didn't say, oh, sometime this fall, to take retirement sometime before the end of the year. No, they told them, hey, it's September 30th. We either need to get a bunch of people out the door, or we need to get some government aid, or both, or people are going to be let go against their will. And under the record, it's highly likely that that group would have included Mr. Freeman. So we think he falls within not only the language of the regulation, but what the regulation was intended to capture, which is, I think, to the court's earlier question, when you have these large layoffs due to unprecedented health concerns, that you're not going to get a date certain for each individual employee, right? They incentivized mass departures by using that date, and that would be my argument, Judge.
Okay. Well, I do appreciate both of you laying it out for me. I think that it was helpful in terms of answering those questions for me. I want to spend a little bit more time with the briefing. And then, as I said, what I will do is reach out to the parties and advise. My typical practice in these cases is to reach out by email and advise you what my ruling is going to be and ask one of you to provide me with a proposed order that I can then edit to reflect what my ruling is. Hopefully that'll be in about the next week or 2 weeks. But I just wanted to let you know that. Any questions or other issues before I bid you good morning?
No, Your Honor, nothing further from me.
Okay.
None from me, Judge.
Thank you all. Have a good day, and I will be back with a ruling as soon as possible.
Thank you, Tim.
Thank you. Mr. Van Gelderen and Mr. Did I lose Mr. Douglas? I did. Do I have Mr. Cannella?
I believe Mr.
Oh, there's
Cannella.
Mr. Douglas.
Yes, there's Mr. Douglas. Mr. Cannella is doing a pretrial conference in person. He's planning to appear soon.
No, I know, but he was trying to get done and then jump on the call. So that's why I keep waiting to see if he's jumped on.
Also, Judge, were you able to see the text message I sent you regarding my communications with the clerk?
Yes.
Okay.
Thank you. Okay, Mr. Van Gelderen and Mr. Douglas. Can y'all both hear me? Mr. Douglas?
I can.
Okay. So Mr. Van Gelderen, I know have you had a chance? I know it's long and you probably have not had a chance to study it, but have you seen that Mr. Douglas filed something?
Yes.
Okay.
It does not comply with your order.
Okay. So here's what my thoughts are. I have reviewed what was submitted, and the motion to set aside, I think, Mr. Douglas, you correctly placed it in the original foreclosure action. Whether that's valid or not, whether it's substantively appropriate to be granted or not, I have no idea. I have no opinion whatsoever. But it is appropriately placed in that case because, as you, I'm sure, figured out, filing it in this case would have been a collateral attack on a standing judgment, which would not have been an appropriate way to proceed. That's number one. Number two, however, was that my order required that your client pay $2,800 into the registry of the court for May and June, which was done. Thank you for providing me with that documentation. But it also required that your client pay rent of $1,400 per month, no later than the 5th day of each month. And according to my clerk, there has been no payment for the month of July, and it is July the 6th. And so there would not be a basis for me to, in this case, further stay any action. Separate from that, your motion to set aside is pending in front of, is filed in a case that is pending in front of Judge Cox. And so what I suspect will happen is that as the result of the lack of payment of the required payment in order to maintain this action, that I will dismiss this action and that you can continue to proceed to the extent that Judge Cox is willing to entertain anything with your motion to set aside in Judge Cox's court. Mr. Van Gelderen, understanding that you've just now seen all of this and that I understand, sir, you have taken issue with all of this from the minute it was filed. Do you have any concerns or anything you wish to add or bring to my attention?
Just a couple things. Your order required a filing of his motion to be filed by the 28th. Just putting the date of June 28th on his motion does not constitute filing. But putting that aside, the only action that would restrain and enjoin my client's title to the property, which really is what he is seeking, it would be an action against the sheriff and my client to undo the sheriff's sale. He hasn't filed that. So there's nothing that in any way impinges on my client's title at this point. He can get a set aside of a money judgment, but that's not going to affect the issue of title. He also doesn't include in his motion anything that would indicate that his client has a meritorious defense, which is necessary to open a default. And that's all I'm going to say.
Right, I understand. Mr. Van Gelderen, I don't necessarily disagree with everything you said, except one thing I will say in Mr. Douglas's defense. Again, the filing issue, the information that we have from our system that we're able to see and you are not able to see is that those documents were filed on June the 28th. They have not been accepted or uploaded by the clerk, which is why you're not able to see them. But the clerk is supposed to, when they accept filings, document that those filings on the day they were actually received rather than the day they were accepted. So the motion itself was in fact filed within the time that was required, but the payment that was required was not filed within the time that was required. And so any stay that I had tentatively issued associated with an effort to possess the Ms. Tribble would be vacated, although I don't know that I entered such an order specifically. And my intention is to dismiss this case, and then the parties can conduct themselves however they see fit. Mr. Van Gelderen, and you're based on what your position is as to the rightful possession of the title to the property, and Mr. Douglas's effort to challenge the money judgment, et cetera. Mr. Douglas, do you have anything to add or any concern? My intention is to dismiss this case and then, yes, sir.
I would only say on my client's behalf and in an effort to continue to have the case stayed so that we don't have to fight about possession. In her defense, she is still required. She still has a mortgage on that property and is still required by law to pay that mortgage.
And Mr. So, Douglas, I understand all that, but there are a couple of things. So number one, I don't think this case is rightly in front of me anyway, right? It should have been transferred to Judge Cox, who signed off on the original foreclosure. And now the issues will rightly be heard, if there are any, by Judge Cox. That's number one. Number two, I will say, in fairness to Mr. Van Gelderen's client, I understand that your client, Mr. Douglas, claims that she does not understand and had no notice and all of this stuff. But at the end of the day, that is the justification that we've heard for a long, long time from your client. And it was made clear that those payments were a requirement to maintain the stay. And she understood that she had to make the $2,800 payment, but she apparently didn't understand that she also had to make the $1,400 payment. And I'm sorry that that is a financial burden on her. I hope that it can be worked out. But at the end of the day, the order was clear that she was required to make that payment, and it was not made. And so as far as I'm concerned, this particular matter is due to be dismissed because of the failure to comply with that requirement. And so I am going to dismiss it, and then I will, the parties may proceed in whatever manner they see fit, probably in front of Judge Cox or not in front of Judge Cox, but it will not be in front of me in this case. Understood, gentlemen?
Understood.
Thank you, Your Honor. May I be
Thank you.
excused?
Yes, sir. Have a good day.
You too.
Thank you, Judge.
Thank you. Okay. So I apologize for the delay, but I am ready now to hear the modality systems. It is 10:13. So if everyone is back, I know I'm a little bit ahead of schedule. 2 minutes, Mr. Halsey. I'm trying to speed up for you.
Oh, hey, we appreciate every bit we can get. So thank you for that, Judge. And I guess I've not been in front of you before, so very nice to meet you.
It's nice to meet you as well. But before you get started, tell me do we have someone here? Mr.
Yes,
Oldham,
ma'am.
are you here?
Yes, I am, Judge.
Okay. So let me call the case for the benefit of the court reporter, so we'll have a clear record, and then we can get started. Madam Court Reporter, are you ready? Okay. This is going to be a hearing in the matter of Modality Systems Limited versus Premier Global Services Incorporated, case number 2023 CV 375-383. I'll note for the record that I have Mr. Halsey here on behalf of the plaintiff, and that I have Mr. Oldham here on behalf of the respondent. I will also note that this is a petition to domesticate a foreign judgment, which I think we discussed briefly during announcements, is typically an administrative and paper-driven process. But that Mr. Oldham, on behalf of Premier, had filed an answer which sort of required us to have a conversation and a more fulsome discussion of the relief that was being sought in terms of domesticating that judgment. And with that understanding, Mr. Halsey, I will hand it over to you.
Thank you, Your Honor. Let me first just introduce who's on the call on our behalf. So we have our client, Modality Systems Limited, is represented by Anna Clark, who's on the line. She's a general counsel for Naystar, which is the parent company. And then we have from Barnes and Thornburg, the law firm where I work, Alexis Deineke, who's also going to speak during the course of this hearing. We have Lisa Wilkerson, who's our paralegal and was very instrumental in helping track down and get certified UK records, not always the easiest thing. And then just sort of for educational purposes, we have Astrid Monroy-Gon, who is one of our summer associates and wanted to attend and watch. So those are the parties on our side. And so with that, let me go ahead and turn the floor over to Alexis to give a very short overview of what we're intending to establish. And then we really just have one witness, Your Honor. And so again, this should be a relatively short hearing.
Okay, thank you, Mr. Halsey. Is it Deineke?
It's Deineke, yes.
Deineke, go ahead, Ms. Deineke.
Thank you. It's a pleasure to meet you. Your Honor, we represent Modality Systems Limited in its effort to domesticate a judgment entered against Premier Global Services by the United Kingdom's High Court of Justice. Pursuant to Georgia's Uniform Foreign Country Money Judgments Recognitions Act, the state of Georgia recognizes final judgments entered in other countries, provided that certain conditions are met. The act here, as an initial matter, applies to the UK judgment because it is a judgment of a court of a foreign country. Subsequently, for the judgment to be recognized by the state of Georgia, it is the plaintiff's burden or modality's burden to establish that the foreign country judgments, one, grants or denies a sum of money, two, is valid, final, and enforceable under the laws of the foreign country, three, is not a judgment for taxes, four, is not a penalty, and lastly, five, was not rendered in connection with domestic relations. By contrast, it is the party challenging recognition to establish that one of 11 bases for non-recognition exist. For example, the state of Georgia will not recognize a foreign country judgment if it was rendered under a judicial system that does not provide for impartial tribunals or procedures compatible with the due process, requirements of due process of law, or if the judgment was rendered or obtained by fraud. Per Premier Global Services answer, the only acceptable basis that it cites to is that the UK court did not have jurisdiction over it in rendering the judgment at issue here. Otherwise, Premier Global Services asserts irrelevant affirmative defenses in its answer, some of which speak to the underlying subject matter or the contract and not the subsequent judgment that arose from it. However, this action is not an opportunity for Premier Global Services to relitigate or attack the underlying contract or subject matter that was litigated in the underlying action. Instead, this action was simply filed for the court to decide whether generally the judgment is entitled to recognition under Georgia law. In that vein, Your Honor, will hear testimony and see evidence today that shows that one, modality has met its burden in showing that Georgia's Uniform Foreign Country Money Judgments Recognition Act applies to the judgment at issue here. And two, that Premier Global Services has failed to prove by a preponderance of the evidence that any of the grounds for non-recognition exist. At the close of evidence today, modality will therefore respectfully request that the court enter a judgment in its favor and against Premier Global Services. Thank you.
Okay, thank you.
Thank you, Your Honor. And with that, we'll call Oliver Glenn Jones.
Okay. Mr. Glenn Jones, I'll swear you in if you'll please raise your right hand. Do you swear that the testimony you're about to give this court will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You may lower your hand. Go ahead, Mr. Halsey.
And Your Honor, in advance of today, we provided yourself and opposing counsel with the bona fides for Mr. Glenn Jones that we believe suffices to establish that he is an expert in English litigation and ensuing judgments. We're glad to save time, but if we would like to tender him as an expert based on the papers, if it's not being challenged, otherwise I can go through the exercise of walking through his CV and whatnot. But I guess to possibly save time, I want to see if that's going to be challenged here.
Mr. Oldham, do you have any objection to the court accepting Mr. Glenn Jones as an expert in UK litigation processes?
Your Honor, it sounds to me like he talks a little funny, but other than that, I don't know that that's a valid objection. So no, we'll stipulate that he's an expert.
Hey, thank you, Mr. Oldham. I appreciate that. I think Mr. Glenn Jones probably thinks we all talk a little funny, but that's okay. Mr. Halsey, you may proceed. Go ahead.
Thank you for that. So with Mr. Glenn Jones being there as an expert, we'll get right to it. Ms. Deineke, could you put on the screen the judgment at issue? Mr. Glenn Jones, do you recognize this document marked as Exhibit, I believe this is Exhibit A?
I do, yes.
And can you tell the court how you recognize this document?
This is an order of the High Court of England and Wales. It's the final order judgment in the case of Modality Systems Limited and Premier Global Services.
And is this it's titled an order, but is this the judgment that we're here today to talk about that the modality is seeking to domesticate?
That's correct, it is, yes.
Okay. And let me ask you a couple of preliminary questions. First, is this a judgment for money, a money award?
Yes, it is. If you look at the specific order at the bottom, in 2, you'll see that the defendant is to pay the claimant the sum of £570,000 forthwith. So that makes it a money judgment.
Okay. As you're aware, there are certain types of judgments that are not able to be domesticated here. Those include a judgment for taxes, a judgment for a fine or other penalties, or a judgment for divorce support, or basically anything relating to domestic relations. Is this judgment, does this judgment relate to any of those things, or is it something different?
No, it doesn't relate to any of those things at all.
Okay, and what does it relate to?
Yeah, it relates to the sum of money that is to be paid by Premier Global Services following the proceedings that this judgment was made in.
All right, thank you. And what, just broadly, just for context, what type of proceedings were those?
So my understanding is that the proceedings were as a result of transitional services agreement and a dispute between the parties as to payment under that transitional services agreement.
Okay. Now, one of the questions we're required to establish here is whether this was a final, conclusive, enforceable judgment. Have you reviewed this judgment and other documents with an eye towards making an assessment about that?
I have done, yes.
Okay. And what are some of the other types of documents and information you looked at that would bear on your opinion about whether this is a final, valid, conclusive judgment?
So I've looked at the original claim form and particulars of claim, which is the documents that gave rise to the claim. And then importantly, what I've looked at is 2 documents. The first is a letter from Modality dated the 28th of January 2022 to counsel for Premier Global Services. And that's a letter that is sent under what's called the Part 36 rules of the Civil Procedure Rules in English Litigation. That's a part which deals with the settlement of proceedings. And by that letter, Modality made an offer to settle the proceedings for the sum of £570,000. Subsequent to that, on the 19th of October 2022, Premier Global Services filed a notice of acceptance of that offer with the English High Court. That's dated the 19th of October 22, as I say. And that at the point at which that notice of acceptance was filed, created a valid binding obligation on Premier Global Services to pay the £570,000. What I then see is that subsequently that sum was not paid, and as a result of that, Modality Systems was able to seek to enter judgment for that sum of money, which is what the document, the order dated 11th of November 2022 does.
Let's show you a couple of these documents, and maybe you can talk about the relevant parts that went into your analysis. Let's start with the TSA, or the Transactional Services Agreement, please, Alexis. And so for the court reporter's benefit, this is marked as government's exhibit, or I should say the plaintiff's exhibit B. And I should also note, just so we have a clean record here, that the exhibits that we're going to talk through today, and there's only a handful of them, were provided in advance of today's hearing, both to counsel and to the court. Is this the Transition Services Agreement to which you referred to earlier, Mr. Glenn Jones?
It is, yes.
Okay. And what does this agreement purport to do? Just again, just very broad strokes.
It deals with the transition of services between broadly Premier Global Services and the Modality entities.
And are there aspects of this agreement that you looked at and that were significant in your evaluation about the judgment and whether it's final, conclusive, and enforceable?
Yes, so the key provision from my perspective is section 7.9, which you'll find on page 18 of the TSA. This is the governing law provision, and this provision sets out both the law that governs the contractual arrangement between the parties, and then importantly the jurisdiction that the parties have submitted to in order to resolve their disputes. And as you'll see from that provision, the governing law is dealt with in the first part of it, and the parties have agreed that it shall be governed by in accordance with the laws of England. And then it goes on to deal with the question of jurisdiction, and says that each of the parties hereby irrevocably agrees that the courts of England shall have the exclusive jurisdiction over any legal action or proceeding brought with respect to any of the obligations arising under or relating to this agreement or its subject matter or formation. So that's the subject matter jurisdiction granted by or agreed between the parties in this contract, exclusively the English courts. And then subsequently it goes on to deal with the personal jurisdiction by stating that each of the parties have hereby irrevocably submitted to and accepted with regard to any such action or proceeding for itself and in respect of property generally and unconditionally the jurisdiction of the aforesaid courts.
And to be clear, this is a agreement to which both parties, and including especially Premier Services, Premier Global Services, stipulated.
That's correct. And there is a further point to make in relation to the jurisdiction. At the point in English proceedings where you are served with those proceedings as a defendant, you have to file what's called an acknowledgement of service document. I don't know whether that's available in terms of the exhibits, but that acknowledgement of service has a number of different options for the defendant, one of which is to, if they wish to, object to the jurisdiction of the English courts, so to say that they intend to dispute the jurisdiction. I don't see any grounds, given this governing law and jurisdiction provision, for a defendant to do so. However, would they wish to do so, they could have ticked that box. They did not do so. They indicated an intention to defend the claim and did subsequently go on to defend, thereby submitting to the jurisdiction of the English courts.
And Ms. Deinecke, I think this is one of the documents we also included in our list. Can we just pull that up for the sake of thoroughness here? And so for the record, we're looking at Exhibit L submitted by the plaintiff. Is this the document, Mr. Glenn Jones, to which you're referring?
It is, yes.
Okay.
And if you look
sorry. That's right. Go ahead.
If you look towards the bottom, if you scroll down towards the bottom, you see there, tick the appropriate box. There are three options for a defendant. The third option is to contest the jurisdiction. That's not what's happened here. The defendant has indicated the intention to defend.
And so all these provisions to which you have pointed, or at least both of the provisions to which you pointed on this in the previous document, both establish, I guess, jurisdiction by the English courts. Can we pull back up Exhibit A? And this may be obvious from the how this is styled, but nevertheless, just for the sake of thoroughness for the record, is this in fact a judgment from the English courts, as was stipulated, by the parties as having relevant jurisdiction?
It is, yes.
Okay. And for those of us that sit on this side of the pond, what is the High Court Justice? What is the King's Bench Division? Are those pretty sort of standard commercial courts authorized by the laws of the UK or of England?
Yes, they are. So the High Court is not the most senior court. The Court of Appeal is above that, and the Supreme Court above that. But the High Court is then split into divisions: the King's Bench Division and the Chancery Division. Depending on what sort of case you have, you choose which division to be heard in. Okay, great. I think maybe only one more or two more documents we want to talk about with you again, just so we have a complete record here. So in indicating what you had looked at and what was important in your consideration, you referenced the Part 36 letter, offer and acceptance. So Ms. Steinecke, if we could pull those up, and if you could walk us through these documents and what was important from your perspective, Mr. Glenn Jones, in reaching your conclusion. So let's start for the record. We're looking at Exhibit C, and Mr. Glenn Jones, what is this? How do you recognize it? So this is what is expressed to be a Part 36 offer. So it's an offer from Modality as claimant to the defendant. And as I mentioned before, the Part 36 rule provides that a claimant or indeed a defendant could make an offer to settle proceedings at any point during those proceedings. And a defendant, if they wish to choose to accept that offer, will immediately create a binding obligation to pay that sum of money. So here, what's happened is Modality have offered to settle their claim, which at its height was a claim for around about $988,000 or 745 odd thousand pounds. They've offered to settle for £570,000.
And Ms. Steinecke, could we pull up the next document, the 36 acceptance? So now we're looking at Plaintiff's Exhibit D. Do you recognize this, Mr. Glenn Jones? What is it? How do you recognize it?
I do. If a defendant wishes to accept the claimant's Part 36 offer, it does so by virtue of a notice of acceptance to be filed with the court and provided to the claimant. That is what the defendant, Premier Global Services, has done here on the 19th of October 2022. And at the point at which this document was filed with the court, it essentially brought the proceeding, the claim to an end, and obliged the defendant to pay £570,000 to the claimant.
Okay. Are these the documents we've reviewed? Are those the key ones that you assessed in making a determination about the judgment in this case?
They are, yes.
Okay. So with that said, can you advise the court with respect to the judgment that is marked as Plaintiff's Exhibit A? First of all, is that a final and conclusive judgment?
It is, yes. I should mention that on the question of appeal, it is possible to appeal an order, but the right of appeal only lasts for 21 days. And this order was dated the 11th of November 2022. And I can see from the record that no appeal has been made. So therefore, it is a final judgment and non-appealable.
Okay. And then is this a judgment if within the English courts that you could take and enforce for the sum of money that's indicated in the judgment?
It is, yes.
Okay. As to jurisdiction, both subject matter and personal jurisdiction, is it your assessment that this court that rendered the judgment had both subject matter and personal jurisdiction?
It is, yes.
And the basis for that is what?
So if I go back to the section 7.9 of the TSA on page 18, that is the provision within the contract that provides both for the subject matter and the personal jurisdiction to be implied, to be asserted. It's been agreed between the parties. and then subsequently confirmed by virtue of the defendant choosing not to contest that jurisdiction.
I think I just have one final question. Can you bring back up, Ms. Deineke, Government's Exhibit A, the judgment? You will notice that there is an apostille on this judgment. I think just for the sake of comprehensiveness and ensuring that we're all talking about an official document, can you explain what the apostille is and what does that indicate about the judgment here that we're looking at?
The apostille has been applied by the notary, who has confirmed that this document is a true legal document and a true order of the English High Court.
Very good. If you give me just a moment, Your Honor, just make sure there's no other outstanding questions. Judge, we have no further questions for this witness, and we'll turn him over for a cross-examination.
Okay, Mr. Oldham, do you have any questions for Mr. Glenn Jones?
Judge, I don't think I do. I will say I didn't see, until actually being able to open these documents this morning, there are things such as the offer and the acceptance that I never saw as part of the record. I did review the initial complaint and, before we filed the response, and I was assisted by, counsel that I was working with up in New York. So I think my response may have been a little bit different had I, if I knew now, I knew then what I know now. So I don't have any questions. I appreciate him providing the court with the information that he has.
Thank you, Mr. Oldham. I appreciate your candor. Lord knows, as an attorney, I remember, and I'm certain all of you have been called upon at the last minute with incomplete information to take action to preserve a client's interests. But what I appreciate is when you have the opportunity after having done so to revisit the issue, that you can acknowledge, frankly, what the positions are. So I appreciate that. I especially, Mr. Glenn Jones, appreciate getting an impromptu education on some of the what I am pleased to see are many of the similarities. Everything that you've spoken about, I can identify very clearly the similar structures, functions, and processes that we have as well. So thank you for that and for not condescending to us, because we promise we understand. Excuse me. So the only other record that I would like to make is just to point out that I had originally entered excuse me, an order domesticating the foreign judgment. And that order was vacated for a very simple reason, which was that it was essentially entered with no consent by the party against whom it was being entered, nor the appropriate amount of time for that party to answer. And so, although substantively, I still, I agree with the petitioners that the judgment ought to be appropriately domesticated. At the time, I thought that Premier's point that I had entered the order prematurely since they had filed an answer was a valid one. And so that's why I did feel the need to vacate that judgment. Beyond that, Mr. Halsey, did you have anything further that you wanted to present on behalf of Modality before I see if Mr. Oldham has anything else he would like to present?
Nothing on our side, Your Honor, and we would ask that Mr. Glenn Jones be dismissed subject to rebuttal in the event, something comes up where we might need him.
Okay, thank you. He is. Mr. Glenn Jones, you may be excused unless you, but hold on one second, because you'll probably be completely excused in just a moment. Mr. Oldham, do you have any additional presentation? I know initially your announcement was that I think your position on behalf of your client was going to be to have Modality make its presentation and then essentially leave it to the court's discretion to determine if a sufficient factual basis for domestication had been made. Is that correct? That's
accurate, Your Honor. And I do want to thank the court for actually pointing out and understanding the position that we took with respect to the default. Not all judges would actually go back and look at something and vacate the way that you did. And so I appreciate the fact that you were willing to do that and get the record correct. Like that was the appropriate thing to do. But based on the presentation, based on what I know now, the exhibits I've seen in that, I really don't have anything else to add other than to say, he really does talk funny, but I can understand him, Mr. Glendale. Hey, no, seriously, appreciate you. Appreciate the education and just, thanks for the other side putting on the case that they did. So, Judge, you can do what you think is appropriate under the circumstances.
Okay. Thank you, Mr. Oldham. Anything else, Mr. Halsey?
Judge, we would just request that the judgment be domesticated.
Okay. Mr. Glenn Jones, you are free to be excused if you would like to be. It is the court's determination based on the record that was presented on the papers, as well as the record that has been presented here today, that the judgment ought to be properly domesticated. Mr. Halsey, just to make sure that we have a fully clean record, can your very capable team send me a new proposed order, and we will get that on file for you as quickly as possible. Is there anything else that you need, Mr. Halsey?
We do have one more request,
Yes.
and I want to be real clear when I ask for this, that this is not directed at Mr. Oldham, who I think has done his job, done it well, has been a gentleman through this process. This is really because of his client, who has started in England trying to avoid payment, is continuing to do so now, really directed this, I guess, defense, if you want to call it that, without a real basis for doing so. The Georgia rules, of course, do provide for the allocation of costs. We've done everything we can to try to keep costs down just for the benefit of our client. Nevertheless, responding to, having to respond to sort of the motions that followed our complaint, and then obviously going through a hearing does entail some cost. We would ask that those be added to the judgment here. And again, I want to be real clear. This has nothing to do with Mr. Oldham. It has everything to do with his client, who we think is just engaged in a pattern of sort of evasion, obfuscation. It didn't start here. I doubt it's going to end here. We're still going to be an enforcement phase in front of us. But there has to be a substantial justification for filing a defense that leads to the incurment of costs by us here. And I don't think I think there's almost been admitted as much that there really wasn't that. So we're not looking at this as punitive or anything else. It's just Ms. Clark and her team being able to recover the costs they paid out to us for this exercise of getting ready really for this hearing, and anything that happens subsequent to our filing the complaint.
Okay. Mr. Oldham, what are your thoughts, sir? And before you respond, let me say this. I agree with Mr. Halsey's assessment, as I said a moment ago, gratuitously, that I remember as a lawyer, I know we've all been in a position where a client was in a very bad procedural posture, and you had to act quickly in order to preserve the rights before you were able to have all the information necessary. And it appears to me that that's what you did here. And it seems that Mr. Halsey is willing to acknowledge that, but that's not quite the same as what motivated Premier to undertake the continued challenge to the judgment. What are your thoughts, Mr. Oldham?
Well, Your Honor, there are a couple of statutes that would potentially govern this, 13-611 and 9-15-14. I get that they're not happy that they had to have this hearing, but for example, that was, it's not. First of all, as the court understands 13-611, bad faith would be bad faith entered into prior to the litigation. So, for example, it appears that the client, when faced with the suit in the UK, actually eventually admitted that it owed the money and attempted to do it. Now, and so it didn't act in bad faith prior to the institution of the litigation. Then you get into whether you've been stubbornly litigious or caused somebody unnecessary trouble and expense. The filing of an answer in response to a complaint where you raise, at least from a counsel's perspective, and I'm talking, myself clearly, I appreciate what Mr. Halsey said, but even New York counsel that I'm dealing with, I will state in my place to the court that I was dealing with another law firm up in New York before dealing with the current law firm that provided me with this case. And so I'm not sure what information, any of the attorneys involved had. So there was certainly nothing other than attorneys doing their jobs here. And I, appreciate the fact that Mr. Halsey saw that, at least with respect to me. Under 9-15-14, I know you have to be, it's got to be, frivolous or vexation. I mean, I just don't think those standards are met for purposes of this by merely, especially in my circumstance, of filing a motion essentially to open a default. It wasn't, as a matter of right. So had I come on here and, put a bunch of goofy challenges here that really weren't appropriate, then I think I would say, yeah, Judge, you should sanction both me and, my client. But under the circumstances, I don't think that there's making them prove their case is not anything that would allow for you to, I guess you can do what you want to, but I don't think it rises to the level of awarding attorney's fees or costs under the circumstances.
Okay. Thank you, Mr. Oldham. Mr. Halsey, it's your motion, so you get the last word, sir.
Thank you, Judge. So yeah, let me be real clear. I think we're talking about OCGA 91514.
91514.
I'm really, I want to be real clear. I'm not talking about bad faith or things like this. I'm just talking about, is there a substantial justification that is required to bring forth a defense? Even the filing of an answer in this case entailed a hearing, which requires us to, get an expert, spend time collecting documents, which overseas is, from where we're sitting, not the easiest thing to do, et cetera, et cetera. That's really what we're talking about. And again, this is not directed towards the attorneys. This is really the client who we just think this is driving the train. And this is just this is just the way they operate. And we just think it's appropriate here for those reasons, Your Honor.
Okay. I agree with both of you. I don't find fault here with what Mr. Oldham did in the circumstances that were presented to him. And I suspect that that's largely been the issue with the attorneys because in my experience, I'm sure in your experience, by the time you get to the second or third attorney, there's usually some context there about why you keep having to find new counsel. And so I do not fault Mr. Oldham for taking the action that he undertook. But I do believe that modalities motion is well taken as against Premier, and that Premier is appropriately, can be appropriately held responsible for the costs and fees associated with the efforts to domesticate the judgment here in Georgia. Mr. Halsey, I think what you would need to do in order to satisfy the procedural requirements of 91514 is to provide the court with an affidavit or documentation regarding the nature of those costs and fees. Let me be clear, since we do have a record, that 91514 authorizes the recovery of costs and fees from the party and or the attorney. And I do want to be very clear that my order will authorize the recovery of costs and fees from Premier and not from its attorney. Anything else, Mr. Halsey?
No, Your Honor.
Anything else, Mr. Oldham?
No, thank you, Judge.
Okay, thank you. So just last, in terms of structure, here's what I'd like is go ahead so we can get it on file and send me the proposed order that domesticates the judgment. In terms of your motion under 91514, I will require the additional information. And so before I can rule. So if you want to include as part of the order that the court, subject to a demonstration documentation of the amount, has determined that a legal basis has been made for an award of fees and costs against Premier. You can include that in your initial order and then subsequently provide me with the additional information. And once I get that and confirm that those fees were reasonable and necessary, then I will enter an order under 91514 awarding those fees and costs against Premier and in favor of modality. Anything else?
That'll do it, Your Honor. We thank you very much.
Excellent. Sorry for the delay. Thank you for your patience. Mr. Oldham, I'm sorry. Did you have something?
I'm just saying no thanks, and we can be excused, I take it.
Yes, you all may. I just wanted to tell you, was it Monroig? You have watched a bunch of great attorneys, including one from a whole nother country. But I love to have young lawyers here, and so I'm sure that you're learning a great deal. Thank you all for your time. Have a good day.
Hey, thanks, Judge.
Thank you.
Okay. Mr. Friedhoff, where are we with Mr. Cannella?
I haven't heard from Mr. Cannella during this time. I'll check my emails one last time, but it doesn't say I have any waiting. No, I think the last time I heard from Mr. Cannella was at 9:45 a.m., but he was simply referring to whether or not he could do this tomorrow. Before that, he said, I will get on after this first conference. Thank you. And that was at 8:56 a.m.
Well, so.
And
I
as you
am
know,
happy-
Mr. Jacob Ebby is not available
Yeah.
today or tomorrow. So it would be up to you to decide if we're going to reset and when.
Well, no, I mean, so I'm trying to avoid, hi, Ms. Vest, hi, Mr. Bossler. I'm trying to avoid ex parte communication, but I mean, I've looked at the conflict. I certainly understand the conflict for today. I've looked at the leave of absence for Mr. Eby. I certainly understand that. My intention is that this matter, I mean, I believe Mr. Eby's leave ends on the 10th and the 11th is a Tuesday, I think. And I am sort of wide open the week of the 10th and the week of the 17th. And so there's really no reason that I can't accommodate a fuller pretrial hearing and then potentially the trial during one of those 2 weeks. And that's really what obviously we need to have a full pretrial conference, but that's sort of what I was hoping we could get if Mr. Cannella was able to join us in terms of, because I certainly understand the position that Ms. Vest is in, that you probably do not have full decision-making authority in terms of being lead trial counsel, et cetera, on behalf of Mr. Eby. And so I think we're limited in what we can actually accomplish in other than trying to target scheduling. What are your thoughts on that, Mr. Bossler?
Yeah, Judge, that's fine. Whatever, if we want to put a full scale pretrial when everyone's available that week, I'll make myself available.
Well, one of my thoughts was rather than to, pretrial conferences can be helpful to make everybody resolve. I know I've heard from you, there's a possibility. What I may be inclined to do, and that's really what I would like a little bit of feedback from you, is simply to set the case for trial and have you come in and let's just go. And that morning we'll take up motions in limine and whatever in the interim. That way I don't take up a half day and then a trial day from you guys if we don't need one.
That's fine, Judge. I will point out, I have a leave of absence as well that extends through the 17th.
Okay.
But in any event, certainly that second week sounds like if the court's available, we could set it during that week and just go as you framed it.
Okay. Ms. Vest, what are your thoughts on that? I did look at Mr. Eby's leave of absence. I don't think he's got to leave until after the one in July 10th until August. So
That's correct, Your Honor. So he should be available.
okay, we're going to look at our calendar, figure out when we're going to put that bench trial that we were just talking to a minute ago, and then we will give you guys notice as soon as possible. But I suspect, Mitch, July 17th is a Monday, right?
That is correct. And that is when this case was originally set to go.
Right. Is it a group 2 day? Is July 17th a group 2 day?
Let me confirm that, but I believe so.
Okay.
Hold 1 second.
And Mr. Bossler, you said you have a leave in place that takes you all the way through the 17th. Is that right?
That's correct.
Okay, but you could go the next day or the day after. Is that right?
Yes.
Okay. And do you have any idea of announcements in terms of how long any party believes the trial might take?
2.5, I think is fair. Maybe 3 days, I think is a fair assessment.
Does that include picking a jury?
Correct.
Okay.
Well-
Ms. Vest, any thoughts on that? Or does that sound roughly fair to what you believe the discussions are?
Yes, Your Honor.
Okay. Okay.
Monday
That is the information. I'm sorry.
Monday, the 17th is in fact a group 2 day, Judge.
Okay. Yeah, that's what I thought. Okay. So I think that then what we're going to do, if y'all can report back to your respective partners, we are going to kick the pretrial conference down the road. We are going to pull this in for trial as we noticed it. But it will likely be on the either 18th or 19th in recognition of Mr. Bossler's leave. And we will target that to start to run about 2.5 days. And the only thing I will ask is, since we are going to dispense with a formal pretrial conference, to the extent you have questions about procedures and anything like that, reach out to Mr. Freehoff. And I do have motions in limine, but I will still need document lists, exhibit lists, et cetera. Other than that, if you guys resolve the case, you're free, because sometimes I know you get to a resolution and then it takes 30 days or 60 days to get those final payments made. You're free to file a notice of settlement and let me know that the case is settled, and that will get you moved from the trial calendar until you file whatever dismissals the parties agree to.
Mr. Cannella is logged
Yeah,
in.
I see his audio attempting to attach. Mr. Cannella,
Yes, Your Honor. Good
how are you
morning.
doing, sir?
Good. I'm sorry. I ran here as soon as I could.
No, it's fine. It's fine. I was actually just sharing with Ms. Vest and Mr. Bossler that my intention, given the leaves that different people have in place, and what Mr. Bossler, I think, it hopefully said he is cautiously optimistic that the parties are working toward the possibility of a resolution. That I think what I'm going to do is keep it set for trial the week of July 17th, except it would either be the 18th or 19th because Mr. Bossler has a leave, that we would dispense with the pretrial conference and simply call you in on that day. We'll give you notice of what day it will be. And that if you guys are able to resolve the case in the interim, all you need to do is let us know and file a notice of settlement that will get you removed from the trial calendar, and we will just await and follow up with you in the actual dismissal when all the boxes are checked and the T's are crossed and the I's are dotted. Does that work for everybody, Mr. Cannella?
Yes, Your Honor. That's fine. I also have leave for that Monday, so that works out good.
Oh, okay, excellent. Yeah, it's hard to try a case in July, and to add to that, that I'm picking on my civil cases because the prosecuting attorneys have a conference that week too. So, but I do appreciate your patience and your time. I hope you were able to multitask and that I didn't take you too much away from other matters that you needed to attend to. Anything else you need from me?
The only thing is so are we called in automatically for Tuesday, Wednesday, or we'll just hear from y'all if we don't, if we're not able to
we're gonna email you the exact date, whether it will be Tuesday or whether it will be Wednesday, but you guys are first up and you are it. It's just a matter of whether I can call you in on Tuesday or whether with my other scheduled matters, I will be waiting till Wednesday. But Mr. Freehoff and I are going to have that conversation today, and we will notify you tomorrow that you are to report on X date at X time, ready to pick your jury.
Okay. I understand. Thank you.
Thank you all. Have a